Subject matter jurisdiction is significantly different from personal jurisdiction. Both have constitutional roots and both create a potential absolute bar against a court hearing a given dispute. But they play very different roles in our judicial system. Personal jurisdiction is there to protect defendants. Subject matter jurisdiction is there to limit the authority of courts, to protect society at large, and to protect the government from itself. The role and purpose of subject matter jurisdiction significantly affects its scope and governing rules. And if you understand the policy and the policy differences between subject matter and personal jurisdiction, the practical and legal differences between the two will make a lot more sense. For example, personal jurisdiction is waivable. Subject matter jurisdiction is not waivable. Where a court has no subject matter jurisdiction, it simply lacks the authority to hear the case. It's no different, for example, than a plaintiff and defendant coming together in Macy's, grabbing another shopper, throwing a black rope on her and calling her a judge. Taking a bunch of other shoppers, putting them in a corral and calling them the jury. They can hear the dispute, they can listen to what the plaintiff and defendant have to argue about, but the judge's decision has no force of law. A court that lacks subject matter jurisdiction is much the same. It lacks the power to adjudicate an issue, and if it tries to, it inflicts an injury on society, and more than just simply an injury on the litigants, as in the case of personal jurisdiction. Simply, subject matter jurisdiction can be raised at any point by any party, and even the judge. Personal jurisdiction must be raised by the defendant in his first formal response, the first formal response to the plaintiff's complaint. Here's a hypo, as an example of subject matter jurisdiction. Two corporations are involved in a patent dispute relating to a highly complex piece of biotechnology. The trial takes 2 months. The first 3 weeks of the trial are spent just trying to explain what the invention does. The trial record is enormous. Both sides spend a tremendous amount of money fighting the case. The court ultimately rules for the plaintiff after much time. The defendant appeals to an intermediate appellate court, and that court is concerned that the trial court didn't adequately address some arcane area of patent law. So it sends the case back down to the trial court to litigate that issue, another few months, back up to the appellate court, and reverses again and finds for the defendant. The plaintiff petitions to the U.S. Supreme Court to hear the case. It accepts, and the parties spent countless hours writing briefs, trying to get outside help, and try to write amicus briefs and other things to the Supreme Court, try to give the court a full picture of what's going on here. Finally, oral arguments. 10 years have passed since the plaintiff has filed his original complaint. During the arguments, and almost out of the blue, Justice Scalia leans forward and asks, "Why was there subject matter jurisdiction in this case?" The hush falls over the court, and no one has a good answer. The case is going to be dismissed. It doesn't matter how much the plaintiff and the defendant together protest. They want an answer to the dispute. It doesn't matter. Again, because the injury is not to the plaintiff or the defendant. The injury is to society. The injury is to the system. And the parties can't concede that injury. When we talk about subject matter jurisdiction in a first-year law course, and in most contexts thereafter for that matter, we're talking about limitations on access to the federal courts. But subject matter jurisdictional limits exist in certain state courts as well. When you study for the bar, you might have to learn some of them. And some law schools may cover local state subject matter jurisdictional limits as they relate to the particular area in which your school sits. We're not going to cover those in this lecture. We are going to talk about 2 areas of federal subject matter jurisdiction, arising under and diversity. They are by far the most common and are all that the typical first-year civil procedure law course will cover. We're going to start with arising under jurisdiction.